The team opposing the BBI bill today occupied the floor of the Court of Appeal, where they staged attacks on the BBI appeals before the Daniel Musinga-led 7-judge bench, praying that the court hits the final nail on the BBI bill. Representing numerous petitioners, including economist David D., Third-Way Alliance and others, lawyers Nelson Havi, Professor Kindiki Kithure, Esther Ngawa and Elias Mutuma, among others, reiterated that the executive arm of the government initiated the BBI bill and not Dennis Waweru and Junet Mohamed, as submitted by the BBI proponents.
The first theory is that this was an initiative by one Dennis Waweru and Junet Mohamed. Now I find that to be, for lack of better terms, taking us for a ride.
The lawyer submitted that there was enough evidence pointing to the official gazette notice that established the BBI secretariat and that the two mentioned were not the originators.
The second theory is that it is not Dennis Waweru and Junet Mohamed in their personal capacity, but an entity known as BBI National Secretariat.
The Gazette is not a newsletter, it's not a newspaper, it is not a pamphlet, nor is it a private publication. It is the official publication of the government of the Republic of Kenya, and for that reason, the president in appointing these institutions was acting in official capacity, which is our first argument.
Asked by the judges whether the president would be allowed to join Kenyans to picket for a certain cause, the anti-BBI team suggested that the president, engaging in such activities of ordinary Kenyans, must abdicate from power first, saying the president is not a mere mortal.
Are you saying that the president cannot make a direct appeal to the people and join them in petitioning Parliament, for example?
No, my lord, he cannot. If the president is such a predicament, he has to do which King Edward VIII did.
He has to resign.
He must abdicate.
When we, the people, collectively donate our powers to you individually to exercise on our behalf, you cease to be the people.
The respondents also argued that the BBI bill sought to alter the basic structure of the Constitution and eternity clauses, and that it had created an impure, hybrid presidential and parliamentary system, contrary to the Constitution.
This is what the BBI bill has done. To destroy, to dismember, to eviscerate the basic structure of the Kenyan system.
The Parliament was also faulted for passing the bill, despite establishing illegalities in the document, that the anti-BBI team maintains that the citizens were not involved in the public participation exercise. The anti-BBI team further poked holes in the manner in which IBC conducted the 1 million BBI signatures exercise. The anti-BBI legal team will have the final opportunity tomorrow to convince the 7-judge bench of the Court of Appeal on why the appeal by the BBI proponents must be thrown out. Giverson Minor, K24, Nairobi.